Session of LawScope, where we are going to be talking about the current legal news that has taken place in the second half of February, starting from 16th of Feb up till 28th of Feb 2022. Just like last time, we will be talking about the important court judgments, some important bills and acts, rules and regulations, as well as some important events that have taken place in the legal field in these 2 weeks. So let us quickly begin without any delay. Starting first and foremost with the court judgments and orders that have come in the past 2 weeks. Starting with the first one, that is now going to talk about the concept of equality, gender equality in the case of orchestra bars. Right, so in the case of, or the judgment that has come from the Supreme Court, that is Hotel Priya, that's a proprietorship versus the state of Maharashtra. Now what happened in this case was that the Maharashtra government had imposed a restriction on the number of people that can be employed as singers in the orchestra bars. Now over here in the orchestra bars, it was stated that there will be a total number of 8 people that can be employed in these bars for this purpose, and from this 4 could be male and 4 could be female. This was challenged in this judgment in the Supreme Court, and eventually now what the Supreme Court has said, they have clearly stated that struck down the gender gap that exists in this parameter. So yes, the two questions were regarding the 8 people that were the first restriction, that was for 8 people that could be employed in the orchestra bars, and the second was this bifurcation into 4 and 4, that is 4 males and 4 females. So basically what the Supreme Court has stated is that this restriction of maximum 8 singers is valid. So they have said that yes, this is clearly valid, absolutely correct. However, to bifurcate into only 4 males and 4 females, this is not correct because it leads to 2 violations under the fundamental rights. Number 1 is Article 19(1)(g). Article 19(1)(g) provides us the freedom to practice any profession, trade or business of our choice. Right? Now please understand, this was the first violation that was talked about over here, violation of Article 19(1)(g), and the second one was Article 15 Clause 1 that talked about prohibition of discrimination on certain grounds, the grounds being one of the grounds being gender. Right, so now with accumulation of these, this was held to be a violation of the same. Due to this, now this violation or this gender gap between this was struck down. Now maximum number of 8, yes, it will exist, but this bifurcation has now been deleted. So this is what has come out of the Supreme Court judgment in this case, that is bringing in an end of the gender gap in your orchestra bars. This is specifically in respect of your state of Maharashtra. Right, now moving ahead, let's go to the next judgment, that is General Manager, Appellate Authority versus UCO Bank and others. That is of UCO Bank and others versus Krishna Kumar Bhardwaj. Now in this case, basically the question that came up before the court was to understand 2 things, that is whether the high courts can interfere or exercise their writ jurisdiction that they have under Article 226 and 227, can they exercise the same when it comes to the question of disciplinary inquiries. Now, firstly, let's understand what is this appellate jurisdiction, right? Appellate jurisdiction is basically the authority or the jurisdiction or the power of the court to take up any appeals. Now, what is an appeal? Appeal is basically a redressal where a judgment has already been passed in a certain case, and one of the parties not being happy with the decision, they come up before the court to look into the facts of the case again. Now, when this is happening, please remember there is a lot of time that is going to be consumed by the court. Now, within the appellate jurisdiction of the High Court, we have to understand it is wide enough to cater to all the disputes that arise within the territory of the state. Keeping that in mind, does the High Court have sufficient time? Does the High Court have sufficient time to look into appeals coming out of disciplinary inquiries as well? Now, over here, in this case, the Supreme Court has given a clear stand that no. So far as the scope of judicial review in the matters of disciplinary inquiry is concerned, the constitutional courts, while exercising the powers under Article 226 and 227 of the Constitution, would not assume the role of the Appellate Authority. So, the stand of the Supreme Court has been clarified in this specific case. So, no, High Court's power of judicial review under 226 and 227 does not extend to appeals in matters of disciplinary inquiries. Now, moving to the next one, let's talk about your next judgment, that is Horticulture Experiment Station, Gonikoppal Coorg versus the Regional Provident Fund Organization. Now, in this judgment, basically the question that came up before the court was, is mens rea actus reus? So basically, please understand firstly, here in this case, there was a default on the part of the employer in the depositing of the EPF or paying the EPF, that is Employee Provident Fund. Now, in this case, what had arisen was, is mens rea an essential aspect even in civil suits or not? Please understand, when we are talking about civil suits or civil cases, we have to understand actus non facit rumnisi mensit rea, the basic Latin maxim that governs our criminal law, which basically translates to that every crime requires a proof of a guilty act as well as a guilty mind. मतलब जब तक आपका mind guilty नहीं है, तब तक आपके ऊपर criminal liability नहीं आएगी. This is the basic rule of law of crimes. Now please understand, the same rule will not apply over here in the case of civil cases. So what we are basically trying to come towards is that if the employer is defaulting the payment of EPF, and he tomorrow says that I did not do it with a wrong intention or with a guilty mind, it is irrelevant, because in civil suits, actus reus and mens rea is not a relevant perspective. This is what came out of this judgment. Moving to the next judgment, that is Shrikant ji Mantri versus Punjab National Bank. Now, this judgment basically spoke about the scope of Consumer Protection Act in India. When we talk about the Consumer Protection Act, from the wording itself, we can understand that this act is created for the consumers, right? So, for a customer. Now, consumer basically has been elaborately defined within the Consumer Protection Act. The question comes in whether I can even include disputes between two businesses. Now, basically, the purpose of Consumer Protection Act was simply that we want to provide a quick and a speedy remedy to the basic consumers, right? So, that is what it was going to talk about. Over here, Consumer Protection Act was not created with the intention to deal with disputes between multiple businesses or two businesses. Right, so over here, now talking about the scope of the Consumer Protection Act, in this case, the Supreme Court has stated that the Consumer Protection Act will be restricted to disputes between business and consumers. Right, so businesses and consumers is the scope of our Consumer Protection Act. So basically, with the agenda of a simple and a speedy remedy to be provided, we only have the concept of businesses to consumers that are going to be redressed within the CPA. However, businesses to businesses, these disputes cannot be referred to under the Consumer Protection Act. This is what came out of this judgment, basically a defining aspect in relation of the scope of the Consumer Protection Act. Finishing this off, let's now move to the important bills and acts that have come in the past 2 weeks. We have one important act that has come in, and another perspective in respect of rules and guidelines that have come in the past 2 weeks. Let us quickly begin, starting with the first one, that is Integrated Plant Nutrition Management Bill 2022. This bill is basically for maintaining or for fixing a maximum selling price. This is not a minimum, but a maximum selling price in case of your fertilizers, and second aspect was to control the distribution and quality standards of fertilizers in India. Now please understand, in the past, now we have determined in the past few years that India has become one of the substantial consumers of fertilizers in the world. So we are one of the highest consuming countries of fertilizers. With that, naturally, a situation came up where now we had to look into regulating and controlling its basic aspects. So for this, a new law is being brought up, a new bill is being introduced, that is Integrated Plant Nutrition Management Bill 2022. So now over here, let's quickly just go through the facts of this bill. We have the central government has proposed a law to empower it for maximum, please remember, minimum की बात नहीं हो रही है, maximum selling prices of fertilizers, and to control its quality and distribution. Next thing, the bill seeks to establish another entity, that is Integrated Plant Nutrition Management Authority of India. This is very important because ये आपकी lawful or statutory authority आएगी in relation of your control and regulation in respect of your fertilizers. Next, it is aimed at promoting development and sustainable use of balanced fertilizers, including biofertilizers, nanofertilizers, biostimulates, and organic fertilizers. So these are the basic categories of fertilizers that are going to be looked at and governed under this basic bill. Now, moving to next, another important thing that has come up in the last 2 weeks is that there are now new rules that are being talked about in respect of children on two-wheelers. Now, given the number of increasing accidents and the deaths that have been taking place, the government has now proposed a new set of rules and regulations for the approval of the public in respect of your kids or children on two-wheelers. So, let's quickly understand what all is going to be coming up in this, and then I'll talk about what law is going to be affected by this. So, please understand that the Union Ministry of Road and Transport Highways has notified a new set of rules for kids on two-wheelers. Now, two-wheelers, bikes, cycles, your scooters, all of these are going to be included within these. According to the rules, basic agenda of these rules is to look at and to cater to the protection and the safety of the child. So, a child below the age of 4 years is now going to be made to wear a helmet. Second thing, the speed of this motorcycle carrying a child that is under the age of 4. Now, what is the age criteria? Age में below 4 की बात हो रही है जी. So, child below 4, if any person is carrying a child below the age of 4 years on this motorcycle, the maximum speed can be 40 kilometers per hour. This is very important in respect of facts that you can be asked in your exams. And then lastly, children will also be made to wear a safety vest while they are being, which will secure them to the driver of the motorcycle or motorbike. Right? So, and what are the basic aspects? It should be made of nylon. This harness, it has to be lightweight, made of nylon, and shall be able to support a weight of up to 30 kgs. So these are the various facts that have come in. Now let's try to understand one more perspective, that these rules through which law will they become operational? कौन सा law होगा जिसके through हम इन rules को operationalize करेंगे? So we have the Motor Vehicle Act that will now be the medium for making these rules effective. Right? So this is in respect of protection and safety of children, specifically more below the age of 4. Now, moving to the next aspect, finishing this off, we are going to move on to some important events, days and appointments that have taken place in the last 2 weeks. Starting firstly, we have your President's Fleet Review. Now we are talking about the President's Fleet Review. Yes, you may have done this in your other general knowledge perspectives, but what we are going to be talking about this or why we are talking about this is because this gives us a more clearer picture about the executive powers of the President in the country. So now please remember that the President is also the Supreme Commander of Defence Forces in India. Now, in the basic, doing of this operation or, taking up this task, what all other various things he does is, one of these is the fleet review. So basically, this is what has happened recently. On February 21st itself, the President conducted the fleet review. Let's quickly understand what really happened over here. So on the 21st of Feb, President Nath conducted a fleet review of the Indian Navy in where we have Visakhapatnam, right? So Visakhapatnam mein aapki fleet review is being conducted. Next, being the Supreme Commander of Defence Forces, right, of the Indian Army or the Defence Forces, which is a part of the executive function of the President. The President of India now takes stock. मतलब ये पता करते हैं कि कितनी चीजें, कितने हमारे पास एयरक्राफ्ट्स हैं, कितने हमारे पास सबमरीन्स हैं, ships and so on. So that is what he's doing under this taking stock and the capabilities of the Navy in the fleet review. Right, so this is what the fleet review is going to basically deal with. So the President being the Supreme Commander of Defence Forces, beyond his basic powers of declaring war and peace in the country, this is another perspective that he does take up. Next, the President embarks on a yacht called the Presidential Yacht and reviews the Indian Naval Fleet. Right, in the year 22, this comprised of more than 60 ships and submarines and 55 aircrafts. Right, so these are the various facts of your Presidential Fleet Review. Now moving to the last perspective of the day, we are going to talk about some important days that have come up in and after 16th of February. So we have 3 days that we are going to be talking about over here. First and foremost, we have the 20th of February, that is the World Day of Social Justice. Now, when I talk about social justice, please understand, we have to understand multiple factors in respect of social justice. Now, if I was to talk about your constitution, where do we see the perspective of social justice clearly visible in the constitution? Firstly, you talk about the preamble. Right? Beyond this, we also have certain fundamental rights and DPSPs that deal with this. So, now, social justice basically is the remain just to give justice in respect of social matters. One very good example of this is the reservations that we are so providing. Right? So, all of this is, the basic perspectives that come out of social justice. Understand that 20th of February is the World Day of Social Justice. Next, 20th February is also the statehood day of 2 states, Arunachal Pradesh and Mizoram in India. Statehood day, that is when this state is being created. Lastly, 24th of February is celebrated as the Central Excise Day of India. So, Central Excise Day basically is in relation of your excisation matters, right? So, these are the 3 important days that you should keep in mind in respect of your law for CLAT as well as for LLM, right? So, keeping this in mind, this is all that we have for today. For more such videos, do log into our channel HitBullsEye on YouTube. Thank you, and we'll see you again next time with the next 2 weeks, or with the first 2 weeks of March. That's all. Thank you.